Good morning. I am Father X, talking about how fathers can win their child custody case. Today, we're strategizing around how fathers can overcome the major mistakes that family court judges make. Let's get to it. Why does this matter? In episode 5A, we talked about the best interests of the child and what that means in detail. In episode 5B, we talked about the major mistakes that family court judges make where they're actually not acting in the best interest of the child. In this episode, I'll show you a game plan for how to overcome those mistakes. Many people complain that the court is unfair, but complaining doesn't get your kids back. Strategizing and outmaneuvering the judge gets your kids back. So let's get to it. Let's talk about how to overcome these mistakes. First, you need to recognize who your enemy is. Often, a custody case isn't about the mother versus the father. When you see how judges make decisions, you may come to realize this custody case is the mother plus the judge versus the father. Once you realize the judge is the enemy of the father and the child, then you know your goal becomes to cut the judge off at the knees to prevent her from making terrible decisions for your child. So how do you do that? I knew that in the long term, the final custody order after the trial had to be based on the best interests of the child. My strategy was to completely neutralize my judge's gender bias, laziness, and incompetence. I set out to prove that I was a better parent across 100% of the relevant factors, which were about 12 of them for us. I didn't want the judge to have even one excuse to say the mother was better at even one factor. So I prepared my evidence and testimony to prove that I was better across the board. That's how I won. For your trial strategy, I recommend that your starting point is to try to prove that you're better at all of these factors. Otherwise, you leave your child's future to the whims of a judge. But don't worry if you can't achieve perfection. The goal is to work with what you have as best as you can. The more factors in your favor, the better your odds. You want to block the judge from just cherry-picking 3 things that justify a decision to rubber stamp the mother. In my case, I recognized that the judge was only making decisions in the best interests of the mother. In order to change that, I used the best interests of the child in my testimony and evidence to corner the judge, and then the situation looked more like this. I used the 12 best interest factors as a blockade against the judge's desire to rubber stamp the mother. I used the prior decisions of the appellate courts to essentially handcuff the judge. For those of you that know some military strategy, what I did here was a form of the pincer movement, where I attacked the judge from multiple sides so that she couldn't maneuver herself to align with the mother. I gave you the best interest factors in episode 5A. For the long term, for your custody trial, you'll ultimately testify in court. I want you to spend the coming weeks and months preparing your evidence and testimony and lining up witness testimony to prove that for each best interest factor, you're the better parent. And I want you to attack each best interest factor one at a time, methodically. This will not be a 2-hour exercise. It'll take you weeks and months of work to come up with all of the actual ideas and facts to demonstrate your strengths and weaknesses as a parent, as well as the mother's. So you need to dedicate a lot of time to this effort. In the short term, before you testify in your trial, you'll have court appearances every 4 to 6 weeks for 10 minutes each time, where the judge, the lawyers, and the mother talk about nothing, but continue to rubber stamp the mother for temporary primary custody. During these court appearances, you should ask for more parenting time, whether it's 2 or 3 days every week or equal custody. And every time you ask, it has to be based on your desire to meet specific needs of your child, not based on what is best for you or the mother, and not based on your equal rights to parent, because the judge has already shown you they don't care about your rights. In those appearances, every time you speak, make 1 or 2 points about how you can meet the needs of your child. The judge may deny your requests for more parenting time. Expect that to happen. But what you're really doing here is building the foundation through repeated requests for the judge to believe you're the parent more attuned to the needs of your child. That's a strategic move to chip away at the judge's bias until you get to your full testimony. at which point you'll destroy the judge's bias with tons of facts. Don't focus on only 2 or 3 factors. In episode 3B, I shared that one of the major weaknesses of family lawyers is that they use the standard playbook of presentations, where you only try presenting 3 or 4 key points. The major flaw with this strategy is that it leaves the judge 10 other things to justify why the mother should have custody. So that's a terrible strategy for you because it leaves you wide open to the whims of the judge. Many lawyers are afraid that too much testimony will just bore or confuse the judge, and lawyers often want to appease judges at your expense. However, the strategy of focusing on 3 key points has led to the current outcome where moms get custody like 90% of the time. You need a strategy that can actually work. So if your lawyer disagrees with my strategy, remind him that you're the client and that your strategy is going to be to overwhelm the court by proving you're a better parent across 10 or more best interest factors, and your lawyer has to get on board. Before we proceed, here's a reminder to like, subscribe, and share. This will help the YouTube algorithm get this message out to more fathers in our position. Do not be brief or concise with your testimony. Many lawyers advise their clients to prepare testimony that's very brief, so you don't get yourself in trouble by rambling or making yourself look bad. Lawyers are often scared of their clients speaking, but that kind of advice has led to mothers getting custody like 90% of the time. I recommend you prepare testimony and stories that are very detailed. I gave very detailed blow-by-blow accounts of the mother's violence and other detailed stories of how I was educating my son. When you use great detail, it tends to show you're telling the truth. How else would you know all these details? And with every detail, you're flooding the judge's mind with reality, so that reality replaces the standard stereotypes that are already in the judge's mind. Some parents testify for as little as 30 minutes or maybe a couple of hours, hoping to get primary custody. I testified for 28 hours over 14 trial dates. We're talking about our children's lives. Are you telling me that my child's future is supposed to be decided based on a 1-hour conversation? That's kind of stupid, right? My son is worth so much more than that. So is yours. So you should flood the courtroom with reality, and it might take you 10 to 20 hours of testimony. I want you to think about both the past and the future. Before the parents went to family court, what actions did you take related to each of these best interest factors to show that you have been the better parent? What stories and evidence can you present to prove that? And you also want to show that the mother did not do these things, or that you did it better than the mother. This doesn't mean you have to be overly negative about the mother. If she has some positive attributes as a mother, that's okay to say. If you're going to be critical of the mother, be critical and harsh about major things that she did that were detrimental to the child. This includes actions like her domestic violence, her anger management problems, or neglecting the basic physical or medical needs of the child, etc. Don't be harsh and critical of the mother for meaningless, minor things because it makes you look controlling and petty. For example, if your toddler falls and hits his head, don't accuse the mother of neglect, unless she was doing drugs in the other room. Toddlers fall. It can happen during your parenting time, too. So, if something happens during your parenting time, and you would be insulted to be labeled a negligent parent, then don't accuse the mother of that either. Thinking this way makes you come off as a responsible grown-up instead of as a petty litigant, and hold the mother to that high ethical standard too. Also, analyze your own weaknesses and how the mother plans to attack you as a bad parent. You have to be prepared to explain those things. Either prove them false, or, if they're true, explain the total context around the incidents and how you learned from them. If the mother's complaints about you are petty, then show them to the judge as petty, to make her look like a petty litigant instead of a loving parent. Think about the future. Until your child is 18, What do you need to provide your child so that he has the best chance to become an emotionally stable, contributing member of society and the best person that he can become? Talk about their future education and social development. You want to show the judge that you're actively thinking about your child's future. You want the judge to know that you'll take the necessary actions to promote your child's well-being. The fact that you talk about what you'll do over the next 5 to 10 years will be a great indication to the judge that you'll probably execute it. In my case, in the mother's testimony, she didn't discuss what she would do to raise our son to be the best he can be. She just primarily focused on her false allegations of my domestic violence and on her ability to change the child's diapers and feed him when he was a baby. Fully prepare for your case. Once you identify the key best interest factors that relate to your case, then you'll go ahead and create summaries for your strengths and weaknesses and the mother's strengths and weaknesses related to each individual factor. And when you present it in your testimony to prove your case, you'll need to present 3 things: your testimony and stories about you, the mother, and the child, documented evidence to back up your testimony, if available, witnesses that can testify to back up your testimony. I was extremely methodical about organizing my thoughts and preparing my case. You should think about your case in a very structured way to organize all of this information for the judge. The judge is your audience, and so are the courtroom employees who have influence over the judge outside of court, which I discussed in episode 4B. When you present your case, be very detailed, because the judge and the court employees don't know you or the mother. They have no clue about what happened in the home. So prepare this as if you're making a presentation to a completely uninformed person. The judge can't read your mind. Be very clear and assertive about the facts. You don't need physical documented evidence for every story you're going to tell. Documented proof is a very important added bonus. You might have documented evidence for 25% of your testimony, or maybe 50%, or 75%. The more the better. But don't feel that you need to back up everything you say with evidence. You should feel confident that when you tell truthful stories with clear and convincing details, that can be sufficient. After all, the mother is in the same exact position as you in terms of documented versus undocumented testimony. So if you have evidence, bring it in to back up your story. If you don't have evidence, tell your story anyway. If you have a witness confirming your story, that also helps. The best witnesses are often neutral witnesses like a teacher, a therapist, or a babysitter. The judge probably assumes that your family and best friends will only say nice things about you. But if your family and best friends are necessary to testify about the mother's domestic violence or anger management problems or other parenting issues, then you need to use those witnesses. You also need positive witnesses who have seen you parenting your children. Family and friends are good. Neutral witnesses can be better because they don't have a vested interest in you personally. In our next episode, we will discuss my first day in family court, which is extremely important because temporary orders usually last a long time. And we'll also get into the trial timeline and what happens during the 3 years of your trial, because you need to plan for all those events. These might be the darkest days of your life, and I'm making these educational videos to help you navigate this nightmare. If you subscribe, you can get updates when I post more videos. Thank you for liking, subscribing, and sharing with your friends who are in a similar situation. If you like, subscribe, and share, it'll also help the YouTube algorithm get this message out to more fathers in our position.